Good morning, everyone, or good afternoon, based on where you are at the moment. I hope everyone's had an excellent start to their Monday mornings. We can start in 4 minutes. I just want to give some time for the others to join us before we begin. I think we should be okay to start now. I'm sure more people will join as we begin. So hello again, everyone. My name is Melanie, and I am the South Asia Regional Litigator for the Global Strategic Litigation Council for Refugee Rights. And I'm based at the Migration and Asylum Project in New Delhi. Thank you so much for taking out some time at the very beginning of your week to attend the global virtual event series, Legal Tools for a Changing Climate. Today is the Asia Pacific launch of two powerful new tools to protect the rights of communities affected by climate change and disasters. In particular, we will be talking about a practical toolkit on international protection for these affected communities, and the climate mobility case database, a first of its kind open source resource tracking legal developments across the globe on climate displacement. Today, we're also joined by Professor Jane McAdam, who's affiliated with the Caldor Center for International Refugee Law, and who is also the co-author of the toolkit that I just mentioned. And Matthew Scott, who is affiliated with the Raoul Wallenberg Institute for Human Rights and Humanitarian Law. Thank you very much to the both of you for your support, and it's really a pleasure to have you both here. Today we will first be hearing from Jane on the toolkit, after which Matthew and I will be discussing the climate mobility case database before ending it with a more interactive Q&A session. But if you have questions anytime through the webinar, feel free to drop them in the chat and I'll be collecting them and we can address them towards the end of the webinar. So yeah, before handing it over to Jane, I want to briefly introduce her. Professor Jane McAdam is a Scientia Professor of Law, Australian Research Council Laureate Fellow, and the founding director of the Caldor Centre for International Refugee Law at the University of New South Wales in Sydney, where she also leads the Evacuations Research Hub. She is a fellow of the Academy of the Social Sciences in Australia and the Australian Academy of Law, and an honorary associate of Oxford's Refugee Studies Centre. Professor McAdam publishes widely on international refugee law and forced migration, with a particular focus on evacuations and mobility in the context of climate change and disaster. Her legal analysis has been adopted by courts, governments, UN bodies, and her work has been highly influential in the development of international, regional, and domestic policy frameworks. Thank you. It's great to have you here, Jane, again. Over to you.
Thank you very much, Nandini. It's a great pleasure to be with you today, and I'm coming from the lands of the Darramurrugal peoples here in Sydney, and I would like to pay my respects to elders past and present. Nandini, I wonder if you might be able to put up the slides, please, and apologies to everyone as I kind of politely direct Nandini through the slideshow, which she's going to operate for me. Terrific. Thank you. All right, we can probably go straight to the next one. Thank you. So just to begin, I briefly wanted to mention where I'm from. Nandini already mentioned that, the Caldor Centre for International Refugee Law at UNSW Sydney, which was established in 2013 as a bridge between research, policy and practice, housed obviously within a university, but having a broader outreach than scholars alone. And our mission is to champion principled solutions for and with displaced people. Next slide, please. And so we have basically three, what will I call them, kind of priorities or hubs of the way we work. Research, to produce world-leading research that supports the development of lawful, sustainable and humane solutions for people in need of protection. Engage, to meaningfully engage, to inform public policy on refugee law and forced migration, including law reform. And finally, to connect. So we seek to connect and resource others in the field to help generate rights-based solutions to displacement. Okay, let's go to the next slide, which is what I'm really here for today, which is to address you all about this new practical toolkit that we've developed. And I'll say a little bit more about that in a moment. To introduce you in particular to 5 key considerations for decision makers and legal practitioners, which are part of this practical toolkit about addressing international protection claims linked to the impacts of climate change and war disasters. To briefly touch on the role of existing refugee law and human rights law in this context, how non-reform obligations may prevent people from being removed. And finally, just some case law examples. Next slide, please. So just to set the scene, this is a map, and I appreciate it's very small, but it's really to give you a snapshot of global internal displacement figures that were released just last week by the Internal Displacement Monitoring Centre. And these show displacement that has occurred within the borders of countries around the world, that is either linked to conflict or violence or disasters and climate change. And obviously those things can be interrelated, but broadly speaking, firstly, what this shows is that displacement in the context of disasters and climate change is already happening. It's not a future phenomenon alone, it's happening in the here and now. But significantly, in 2024, there were close to 20, or a bit more than 20 million new displacements resulting from conflict and violence, and nearly 49 million displacements in the context of disasters. Now, that's a huge difference. Around 70% were linked to the impacts of disasters, and that's notwithstanding the significant conflicts that we're seeing at present and last year around the world. Now, as I've mentioned, this is for internal displacement. We don't have great data on cross-border movement, but we do know that some people will move across borders. And the data is limited too because, as I mentioned before, it doesn't really show how conflict disasters could be intersecting here as well. But clearly what it shows is that disasters, natural hazards are having a significant impact on displacement. And given climate change and the trajectory that that is having, and the way that climate change amplifies the frequency and the severity of disasters, it's likely that we're going to see growing numbers as the years go by, growing numbers of displaced people. And some people move because they've already experienced harm. Some people move in anticipation of what they think might happen. Next slide, please. We're also finding that decision makers and legal practitioners around the world are increasingly being called upon to assess whether and how the impacts of climate change and disasters are causing or are likely to cause harm, and whether people are entitled to international protection, whether as refugees or as beneficiaries of complementary protection or subsidiary protection, as it's known in Europe. Over the last 10 years and more, we've seen a significant number of new cases emerge, international guidance that has shown quite clearly how in the right factual scenario, some people could indeed qualify for protection as refugees or beneficiaries of complementary protection, where climate change or disasters affect the claim. So what these cases tell us is, and the guidance too, is that there's no need to reinvent the wheel necessarily. I mean, of course, you could go out and create a whole new treaty, but there is no political appetite for that. So what the cases tell us is that using the existing legal tools we have right now, some people can qualify for protection. So what we wanted to do with this practical toolkit was show how that's the case, draw together all the existing materials we have, and importantly, to show how disasters can interact with the broader social and political context and other drivers of displacement. So that's why we developed this practical toolkit on international protection for people displaced across borders in the context of climate change and disasters. And the we I refer to here is the Caldor Centre, so me and my colleague, Dr. Tamara Wood there, together with Kate Jastrom and Felipe Navarro from the Centre for Gender and Refugee Studies in the United States, and Jeff Gilbert from Essex Law School and Human Rights Centre in the United Kingdom. And we did this with the support of UNHCR. We also consulted very widely with decision makers, legal practitioners, UN officials and other legal experts around the world, and we're very grateful for their input and their engagement. And just from the Caldor Centre side, I'd also like to thank Open Society Foundations for their financial support for this project. So what the Practical Toolkit notes in one of its quotes is that in the context of climate change and disasters, international refugee law and human rights law applies in the same way as in any other context, prohibiting the refoulement of those at risk of persecution or other serious harm. While the relevant legal instruments don't explicitly mention displacement in the context of climate and disasters, where the impacts of climate change and disasters on the ground generate or exacerbate the risk of persecution or other serious harm, those affected may be entitled to international protection. Okay, so let's move to the next slide, please. So what we're referring to is a bit of a mouthful, but displacement in the context of climate change and disasters. And that is because it's very difficult to show direct causation here. What we're talking about is a multi-causal phenomenon, just like other forms of human mobility. The impacts of climate change and disasters intersect with a wide range of other social, economic, political, cultural, and other factors, which together can influence somebody's decision to move. The Practical Toolkit analyses international refugee law and human rights law, and also their regional counterparts in Africa, the Americas, and Europe. And as I've tried to reiterate here, what we're doing is looking at how existing law can apply to claims, not trying to create new law. So we're not seeking to extend the scope of international protection here. The Practical Toolkit, in its methodology and examples, draws on existing guidance from UNHCR and others. That includes, for instance, UNHCR's legal considerations document prepared in 2020 on this subject. It includes databases like the one you're going to hear about later on, materials like the Refugee Law Initiative, declaration produced last year, Caldor Centre Principles on Climate Mobility, and many, many other materials that we've drawn on. And we'd also note here that importantly, the Centre for Gender and Refugee Studies in the US, which was one of our collaborating partners, had previously developed national level guidance for US decision makers. So part of what we were trying to do was create a global version of that, but equally hope that that global version then enables other national jurisdictions to develop more targeted guidance that focuses on the specific legislative and policy frameworks in particular countries. And at the moment, we're doing that for Australia. Next slide, please. Right, so this is the table of contents. And what, if you actually do the next click, please, what I'm going to focus mainly on here is the key considerations, which are the overarching considerations that decision makers and practitioners should apply in any assessment of an international protection claim where climate change or disasters might contribute to the risk of harm. And really with these, what we were trying to do was respond to, and I guess in a way debunk, some common misperceptions or oversimplifications about the connection between climate disasters and displacement and the role of international protection. And we felt that by foregrounding these, that provides the kind of lens through which the rest of the toolkit is then understood. And that's where in the rest of the toolkit, we go into looking at those international and regional refugee and human rights law frameworks. I'm going to touch on the international ones later on. Next slide, please. And next click. Thank you. Right, so the first key consideration is that there are no special rules for international protection claims involving climate change and disasters. And by that, what we mean is that protection claims that arise in this context should be assessed in the same way as other protection claims. In other words, through a systematic application of the legal criteria to the established facts of the individual claim. I think sometimes decision makers or practitioners see climate change and think, oh, I'm not an expert in that, or I know nothing about that, or think refugee laws are relevant. Whereas what we're saying is stop and go about this as you would with any claim, and then we're going to look at how the climate or disaster aspect might fit in. So there is no, firstly, there's no general proposition that everyone displaced in the context of climate change or disasters will be a refugee or will not be a refugee, or likewise will be a beneficiary of of complementary protection or won't be. They might be, and that's got to be the starting point. So as I said, you don't need a specialist understanding of climate science. It's about looking at, as you would in any claim, what is the country information here? What is the particular circumstance of the individual? How might the projected adverse impacts of climate change be relevant to assessing what's sometimes been described as a trajectory of risk over time? And as Bruce Burson, who is a decision maker in New Zealand, has said, what you need to look at is what is the local hazardscape as a whole. And by that, we're looking at what are the environmental hazards and how, and the, you know, how often are disasters happening, where are they happening, and who are they affecting, and how do they interact with the broader political, social context. Next click, please. So this hazardscape needs to be considered as a whole. Typically, people are fleeing from a range of hazards and potential harms. So again, it's important that decision makers and practitioners don't just zoom in on the climate event or the disaster, but look at that broader hazardscape. So, you know, how might all these things contribute to a person's vulnerability, their risk of persecution or other serious harm? Things like food insecurity, water insecurity, or water scarcity, health risks. All these things are that hazardscape that Bruce Bersin talks about. And that's why we also need a cumulative assessment of risk, given the range of human rights that may be affected. So right to life, water, sanitation, shelter, health, and on the list goes. These adverse impacts could emerge suddenly, for instance, if there was a sudden onset disaster, but equally, they could emerge over time. And again, that too needs to be part of this assessment. Next click, please. So the third overarching consideration is that climate change and disasters affect people in different ways. Now, that, on the one hand, that might sound very obvious, but equally it might sound counterintuitive. And certainly some earlier cases that had considered disasters used to say, you know, High Court of Australia, for example, would say, well, you know, they're indiscriminate. But I think what we've come to realise is that, of course, disasters don't affect everybody in the same way, and your existing circumstances are going to be highly relevant, determinative of how you then experience these other factors. And they can be, you know, your age, your gender, whether or not you have a disability, all the, you know, what level of resources you have, whether you've got caring responsibilities, all these sorts of things will affect how you react, what you can do, how you respond. And of course, these aren't just sort of siloed categories, they intersect, and we need to understand people in their whole, you know, diversity and complexity. I think what's really important to recognise here as well is that we shouldn't be seeing these attributes just as individual sort of, you know, problems that affect people, but actually as deeply structural factors that may hinder somebody in a disaster or other situation. So historically marginalised groups, for example, may often be at increased risk because existing patterns of discrimination might mean they don't have access to assistance or protection or social security measures or adequate housing or whatever. Human rights law can also be helpful in identifying the impacts and risks and the nature of potential harms. And that's where you know, we allude to particular human rights instruments that safeguard the rights of children or women or people with disabilities and so on. And they provide us with additional guidance and examples of how harm might affect particular groups or individuals. Next click, please. So the fourth consideration is that human agency contributes to the impacts of climate change and disasters. Now, again, this is important because in some earlier cases, we saw decision makers saying, well, you know, we don't know if it's climate change, and we can't say that a particular disaster was caused by a particular government or anything like that. That's not the point here. The point is that we're looking at human agency contributing to the impacts. So, okay, there's a disaster, but what is then happening on the ground to people who are being affected? And are there, as I've alluded to before, certain systemic policies that may deprive people of their rights, access to assistance, and so on? So the human agency requirement here relates to the risk of harm to the applicant. What we're looking at is human agency being a factor in creating the risk of serious harm or in the state's failure to protect people from such harm. And Another point I just want to bring in here is that we still hear a lot about natural disasters, but in fact, there's not really such a thing as a natural disaster. There are natural hazards, but what turns their impacts into a disaster is their intersection with other broader factors and the government's inability or incapacity to respond. And UNHCR in its 2020 legal considerations says that decision makers should, and I quote here, should recognise the social and political characteristics of the effects of climate change or the impacts of disasters or their interaction with other drivers of displacement. So again, I'm stressing here that the impacts of climate change and disasters depend on the social and political context. Last click for this slide, please. So the final key consideration is that the risk of harm may manifest over time. Now you'll hear, I've made some of these comments before, so each one is kind of reinforcing the other. But what we mean here is that the impacts of climate change or disasters can arise suddenly or emerge over time. And and also their effects can start to be felt over time, even if not instantly. So what this means is that decision makers should be considering a longer time frame in assessing risk, including potential measures a country might take to try and mitigate that risk. And that's, of course, where there can be a challenge. And we see that in some of the case law so far, where decision makers are saying, well, if we send you back tomorrow, it's probably fine. Not sure what it will be like in 50 years, not sure 10 years, so what time frame are we assessing, and where does that scope for adaptation or mitigation come in? Let's bring this back again to first principles of international refugee law, which is the fact that at the heart of all protection claims is a forward-looking, somewhat speculative assessment of risk. So we're always saying in refugee law, is there a well-founded fear of someone being persecuted? Obviously, we're looking to the future, but we don't need a guarantee. It's not on the balance of probabilities. It can be a less than 10% chance, but it has to be a real risk, something that is reasonably foreseeable in a way. But there's no outer limit. And again, even for this, this comes back to this timing point. Even if you have a one-off disaster, we need to be looking at, well, what are the impacts of that and the risk to the person concerned over that longer term, because those impacts might be felt for a long time. In assessing this, decision makers need to take into account the likely increases in climate impacts over time as well, but also, as I mentioned, steps that might be taken to try and mitigate those risks through adaptation or disaster risk reduction measures, sustainable development and the like. So the challenge, as I said here, is to determine, where are we going to strike that balance? And I think a failure by authorities to safeguard against known risks would support a claim to international protection. At least we're trying to mitigate the effects of those, wouldn't pose a disproportionate burden on the government. But if the government is doing everything it can to try and mitigate those risks, to try and reduce the risk of harm to below that real risk threshold, then there may not be such a compelling claim. And obviously, like every case, it has to be assessed on the facts at hand. Okay, so let's just move to the next slide, where I want to have a quick look at the Refugee Convention and then the International Covenant on Civil and Political Rights, simply to illustrate how some of this might play out. Obviously, the Practical Toolkit is a very big document, so it has a lot more detail than I'm going to be able to go through today. So if we could just click through, first of all, to the requirement that a person who is seeking refugee protection has a well-founded fear of being persecuted. Could you just click, please, Nandini? Thank you. Okay. So, as I've already said, persecution may take the same form in the context of climate change and disasters as in other claims. We need to be looking at all the potential harms a person might be exposed to. So again, that's Key consideration 2, consider the hazard scape as a whole. Generally, we need to see human acts or omissions. So that's key consideration 4, the relevance of human agency. So, for instance, an environmental activist might be persecuted because they're opposing government policies. Persecution can arise as a result of existing discrimination or inequalities, which could expose some people to more serious forms of harm. So this is getting to the idea that even in a situation that might look very generalized, the risk of harm to some of the population could rise to that level of persecution, but not do so for others. Drawing here on an example from the Refugee Law Initiative Declaration, there it's mentioned that marginalised groups forced to live in disaster-prone areas or denied access to assistance in the aftermath of a disaster might indeed be people being, that could be a form of persecution. And of course, where governments fail adequately to prevent or respond to disasters, then the resulting harms could amount to persecution. Next click, please, the well-founded fear component. So is there a real chance of persecution? Again, this is the forward-looking assessment of risk over time, taking into account all relevant facts of the case. The applicant doesn't need to show definitely that harm will result. Even a small risk can be real if the foreseeable consequences are serious. And again, drawing on key consideration 5, we need to be looking into the future and into, over a longer time horizon to see what is the trajectory of risk looking like here. And the fact that harm is experienced by a whole community or a large group of people within a community, like women or an Indigenous group, should not undermine this well-foundedness of the fear. In fact, it could actually support it. And that comes through in UNHCR's 2020 Legal Considerations document. Okay, let's click through now. We need the nexus with a convention ground. So as you know, in refugee law, we're not just looking at persecution as this standalone notion. Rather, it's persecution, being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group. So can that nexus be made out? Again, key consideration 3, climate disasters affect different people in different ways. So there could well be a link for particular groups or because of your race or something like that. And as I've noted too, people who are already in marginalised or vulnerable situations can be at particular risk of harm that might rise to the level of persecution, and their shared characteristics may well correspond with one or more of the 5 grounds in the Convention. So an example of a particular social group might be if women or children are left out of disaster preparedness and miss out on relief, assistance and recovery responses. Political opinion, that could be relevant where, as I've mentioned, environmental activists are protesting, or journalists are reporting on certain things, or land defenders. So there are various ways here that, again, the toolkit goes into a lot more detail about how these groups could be implicated. Another click, please. I just wanted to touch here on the internal flight alternative because, again, this can be a relevant consideration as it is in other protection claims in some jurisdictions. Generally, when a government or, when a decision maker is deciding whether somebody has a well-founded fear of persecution, they will also look to whether they could relocate internally in their own country. So that requires them to look at whether there is an absence of persecution in other parts of the country and whether it would be reasonable in all the circumstances to require the applicant to relocate to that safe area if it exists. And a study that Matthew Scott was actually a lead author on, or a co-author of, showed that in Austria, for example, disaster-related factors were considered as part of the internal flight alternative assessment in nearly 50% of cases, even where they hadn't been raised as part of that initial claim. All right, I now just want to turn to the ICCPR on the next slide, please. As I said, this is a very quick tour here. And here I want to look at how, at least at the international level, the right to life and the right not to the right not to be subjected to torture or cruel, inhuman, or degrading treatment or punishment could be relevant in preventing removal, where disasters and climate are playing a role. So under Article 6, the right to life, we have had the UN Human Rights Committee in the matter of Tessiota, New Zealand, explaining that that implied principle of non-refoulement there could protect people from removal in the climate/disaster context where people face a real risk to their life. Now, that was the provision that the Human Rights Committee considered in detail, but in passing almost, they also said that Article 7, the cruel, inhuman, degrading treatment element, the implied non-refoulement principle there too, could also be relevant. We also have the committee saying that the right to life here includes the right to enjoy a life with dignity, and that conditions of life may become incompatible with that right to life with dignity before the risk is realised. Essentially meaning that you don't have to wait until you're about to die. You don't have to wait until you are in the most dire circumstances before a situation may warrant international protection. So in Tessiota, New Zealand, the committee was looking at the situation back in Kiribati for a man and his family who had they had actually been removed there by that time, but they had been resisting removal from New Zealand. And they said that that the right to life should be interpreted in an expansive way, certainly not in a restrictive way. It includes not only a right to life with dignity, but a right to be free from acts or omissions that might result in unnatural or premature death. And it extends to reasonably foreseeable threats and life-threatening situations that could result in loss of life, even if loss of life doesn't eventuate. So you can see this is tracking in line with what we've already discussed in the earlier parts of the presentation. The committee also then noted that in this particular situation, on the facts, they couldn't find that the right not to be removed to a situation of life-threatening harm, that the threshold rather hadn't been met. And so in this case, no violation of the right to life was made out. Article 7, as I mentioned, the torture, cruel, inhuman, or degrading treatment wasn't considered in any detail in this case, but it has been in some of the other New Zealand jurisprudence that we discuss in the Practical Toolkit. There's also comparable case law in the European context, looking at destitution, dire humanitarian conditions, and an acceptance in principle that the principle of non-refoulement would preclude removal, but the threshold is incredibly high. And that's also why we say considering all the facts and factors in a cumulative way is very important here, as is what the state is doing. So I won't go through more of that now. I'll let you have a look at the toolkit, but I just perhaps on the next slide wanted to touch on 2 examples that show how existing case law has approached these issues. So Nandini, would you mind clicking? Thank you very much. So the first one, RN returnees. The important factors in this decision were that the claimants had been denied food assistance, and where there's no other option, this could be persecution. Again, this goes to key consideration 2, consider the hazard scape as a whole. Here, the tribunal held that the applicant would be at risk on the basis of her imputed political opinion, So again, here, key consideration 3 is relevant. That is, climate change and disasters affect people in different ways. I'm really summarising this, so I'll leave it to you to look at the detail. The next one, AC Eritrea, some important factors here were that the government contributed to the risk of harm. So this goes to key consideration 4, human agency is relevant. Also, the applicants here were elderly and thus seen to be more at risk. So key consideration 3, climate change and disasters affect different people differently. Again, lots of other factors were at play there, but it's very interesting to see how the decision maker brought the climate and disaster factors in here as part of that overall hazardscape as well. Okay, so if we could just go to the next slide. We've put up a practical exercise here. It's a hypothetical, and I'll just read it out in case it's hard to see. Salman lives in Azalea, a small landlocked country. He lives with his wife and children on a char, which is a small sand island in the middle of a large river. The family has had to flee many times due to flooding, each time returning to rebuild their home. Recently, the government started a disaster risk reduction program, building stone walls to protect communities on either side of the river from flooding. Because only the poorest families live on the chars, the government has not extended the program to protecting char dwellers. So what I wanted to put to you here is, if someone was in your country seeking protection, do you think he'd be eligible under the Refugee Convention definition? And alternatively, because usually this is the kind of hierarchy, first refugee, then human rights claim. So alternatively, do you think he'd be eligible for protection under human rights law? So because there's a real risk to life, or inhuman or degrading treatment. So as you're thinking about this, you're looking at, is there persecution in this story? The hazardscape as a whole, different people being affected in different ways. What is the fear here, and is it well-founded? What's the risk likely to be in the future? So again, thinking of key consideration 5, the harm manifesting over time. What's the human action or omission here? So key consideration 4 on human agency. What's the government doing or not doing? Is there a connection to a protected ground? The fact he's very poor, is that enough to find the existence of a particular social group? So I'll just let you ponder that for a moment. And I'm not sure if anyone's going to be brave enough or willing to make some suggestions, live, or even in the chat as to what you're thinking. I'm just seeing if we can. Yeah, no, I think that's going to have to be the way that we do it here. I can see some questions coming in as well, which I can get to. Otherwise, I'm happy to, fill you in on what this is based on and where it came from. But I'm wondering, would anybody like to jump in? If not, I'll move on, just in the interest of time.
Jane, I can see there's some comments. Unfortunately, I'm not able to see them because I'm sharing my screen, but
Sorry, I'm finding it hard to hear. There's some comments. Would you like me to address those as well now, or at the end?
We can address them at the end. I'm not able to see them right now because I'm sharing my screen.
No.
So just was wondering if they're in way related to your exercise. Right?
Yeah, I can address those questions right at the end. You mean after Matthew has spoken to? Yeah, okay. All right. Well, in the interest of time, I will tell you a little bit about what we made this hypothetical exercise on. And Wendy's just asked specifically here, would families like this even know they had a right to flee to another country? I mean, that's a good question in any case, I suppose. Do people, and not only do they know they have a right to seek asylum, very often what prevents people is having the resources to do so. And often what happens is people become, as the map at the start showed, internally displaced first, or only because most people don't ever want to leave their country. Some people, even if they do want to, can't for various reasons. So very often people become, and some people become trapped. They can't go anywhere. So they are perpetually stuck in this kind of cycle. Okay, and we've got a response here. All grounds of the Refugee Convention are probably not satisfied in this instance, particularly perhaps the issue of membership of a social group, which may not be defined particularly by geography. The other option is the internal flight alternative. Thank you for that contribution. So I'll share our reflections, and I'm not using the royal we here, I'm meaning me and my co-authors. So the fictional scenario is based on the facts in an Italian case from 2024, which is in the Practical Toolkit, and it's by a tribunal in Milan. So again, the toolkit will give you much more information about that. In the real case, the tribunal said that an applicant from Bangladesh was entitled to subsidiary protection under the EU Qualification Directive. So that isn't refugee protection, that is on human rights grounds. And the tribunal held that the applicant was at risk of inhuman or degrading treatment, which is the equivalent of Article 7 of the ICCPR. This was because of risks to several of his human rights, including life, physical integrity, health, a healthy environment, food, and housing. So that whole hazardscape is coming into play here. Two important things to think about, again, reflecting on the Practical Toolkit considerations. Firstly, the applicant was seen to be disproportionately affected because he belonged to a disadvantaged social class. So this is key consideration 3. People are affected differently. And yeah, I mean, going to that point that Ahmed Ibrahim raised, would this constitute a particular social group under the 1951 Convention? And here the risks arose from what I'll put as treatment, and this is human agency is relevant, the key consideration 4. And this was because it was said the state treated the applicant in an inhuman or degrading way. It wasn't just this is how it is, it was a kind of deliberate decision by the state, because the risks that the applicant faced had been aggravated, in fact, by the state's failure to implement effective environmental risk management policies or basic assistance programs for affected populations. So the final slide then, please, Nandini, is really just to say thank you to you all for your attention. I am very happy to respond to the questions in the chat when we come back to the Q&A after Matthew and Nandini's discussion. Thanks very much.
Thank you so much, Jane. It's honestly a fantastic resource, and I will just be sharing the link in the chat right now, so you can access it, do go through it, and also get back to us if you have any questions. We'll also be sharing the links to the toolkit and the database, which we'll be soon discussing via email. So don't worry, the link will not be lost in the chat at the end of the webinar. That'd be great. All right, so Matt and I now will be presenting the climate mobility case database. I will give you some background on the Global Strategic Litigation Council and how the database was conceptualized and then created. And then Matt will actually be taking you through the database before we conclude. So before I begin the presentation, I want to take the opportunity to introduce Matt as well. Matthew Scott is the head of the Human Rights and Environmental Thematic Area at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden. His primary area of expertise concerns migration and displacement in the context of disasters and climate change, and his work focuses on integrating social science perspectives with international legal standards to promote context-sensitive, human rights-based law policy and practice relating to disaster risk reduction and climate change adaptation. He is a member of the advisory committee of the Platform on Disaster Displacement, a founding member of the Nordic Network on Climate-Related Displacement and Mobility. Matthew is currently contributing to technical expertise on human rights-based approaches to disaster risk reduction across 8 countries in Asia, in collaboration with the Asia Disaster Preparedness Center, the Stockholm Environment Institute, and the Swedish Civil Contingencies Agency. It's great to have you here, Matt. Having introduced him, I will start with the presentation, and then Matt will be taking over later. So just give me a minute to share my screen.
You got muted, Nandini.
Oh, okay. Thank you so much, Matt. Great. So I had just started introducing the Global Strategic Litigation Council, which is essentially a coalition of regional networks in Asia, Africa, Europe, and the Americas. And we have over 550 refugee organizations, nonprofits, lawyers, advocates, academic experts that work on strategic litigation and advocacy across the world for the protection of refugee rights and migrant rights. Our aim has been to collectively use the power of all people and the power of the law to protect and advance the rights of the people who are on the move. Sorry, there we go. Yeah. So as an organization, we support our members to fight back hostile policies, externalization policies that we've been seeing, violent pushbacks, arbitrary detentions, and the denial of equal treatment and basic human rights that is faced by migrants and refugees. In particular, we help our members set priorities within their work for the protection of these populations. We help build community and share knowledge, encourage peer-to-peer learning, and create and execute litigation and advocacy strategies. The Council has recently, over the last year particularly, been conducting a lot of technical assistance and support for our members. This includes support with early stage litigation, amicus interventions, expert reports, law research, and we've also been conducting trainings such as this one and the ones we've conducted in the past. I can see some people who have attended those trainings as well. So yes, we conduct such trainings based on our members' needs. And to drive this global collaboration and to maximize the collective impact of our members, along with our members, we've identified certain key thematic priority areas that we support on. This includes climate displacement, detention and due process, and legal status and local state. In general, the idea is to create a community building environment for people working in the area of law for maximum impact. And if you are interested in joining the Council, I will, towards the end of my presentation, I will be sharing a registration form. Please do join us. And if you need any support in the form of advocacy, legal assistance, anything, I'll also be sharing a support form which you can fill for support. You can also reach out to me. I'll also be sharing my email ID at the end of the presentation. All right. So as I mentioned, one of our key priorities is climate displacement, and to build our work on this and other issues as well, we actually held a series of in-person consultations in different regions across the world. And it was during these meetings that climate displacement emerged as a key issue and a priority. More specifically, we realized that there was a need of a global public library of litigation cases related to climate mobility, given that it is a new and emerging issue, not issue, but like in the field of law. Yeah, so given this need, we wanted to also encourage litigation and advocacy on this issue. And together, therefore, with Earth Refuge, the Raoul Wallenberg Institute, and the Zolberg Institute on Migration Mobility, we are very happy to announce our climate mobility case database. As I mentioned earlier, it's a one-of-a-kind open access resource which tracks legal cases across the globe on climate displacement and people affected by it. We've worked on it for almost 1.5 years to curate this, and it's unique in the way where it does not just tell you about the cases or the case summaries, but it can also tell you the lessons learned or the challenges that were faced in litigating these cases, and how that can be used to strategize any future litigation in any region of the world. It also encourages cross-border, cross-regional collaboration and learnings. We will also be having spotlight blogs on the database, where we will include insight and analysis from any trends that we discover while working on, expanding this database. We'll also be including blogs from affected communities in an effort to amplify their voices. Yeah, we really hope this helps guide practitioners in their litigation and advocacy. But before, I think Matt will be taking over now to take you through the database. I'll stop sharing my screen. Over to you, Matt.
Thanks, Nandini. I just saw a request in the chat, so I posted the link in case people want to follow there. In the meantime, I'm gonna link to the presentation. But I'm gonna give you a quick view of the document just because that's what's on my screen first. So what I'm gonna do in a fairly short order is provide a little bit of a guidance. Sorry, I'm not expert in sharing this screen. Too many things open at once. That should be, is that a good visual? So, I'm going to introduce the climate mobility case database in a bit more detail. And what that means is, first, I'm just going to give a little bit of an overview of some of the kinds of cases that are captured there before actually walking you through. And walking you through, I'll make reference to some of the kinds of cases that I'm just going to touch upon now. So I've just got 2 slides, and I don't think there's a lot of benefit in giving a deep overview of the kind of legal doctrinal insights that emerge from looking at these cases. But really what I want to do is highlight the existence of a variety of cases from a lot of different jurisdictions relating, and I'm going to switch back and forth a couple times, but relating both to cross-border as well as internal displacement. And if you remember at the beginning of Jane's presentation, you saw the map produced by the Internal Displacement Monitoring Center showing the scale of internal displacement in the context of disasters and climate change. And it's therefore highly relevant and I think quite an innovative dimension of this initiative to showcase the judicial and quasi-judicial engagement with internal displacement as well as cross-border displacement. Right now on the database, there are 75 cases that are showcased with summaries in details that I'll show you pretty soon. But that's only part of it because we have at latest calculation, a total of 196 cases comprising internal and cross-border displacement that are, including those 75, waiting to be summarized and integrated into the database. So this is a resource that will continue to grow rapidly. And part of the reason why we don't have all of them up yet is because we've been working to figure out basically a way to make those available quickly with limited human resources. And I'll talk about the AI dimension in that. But think about 196 cases waiting to be reviewed, encouraging you to come back for more if you're not satisfied with the 75 that are currently available. But in terms of cross-border cases, you can see on the slides here reference to cases from Italy, France, Germany, Switzerland, Belgium, Norway, Sweden, the UK, Australia, New Zealand, the USA, which is interesting and maybe also, I'm not sure if disappointing is the word, but the reality is that a lot of international refugee law and international protection decision-making in a judicial setting takes place in countries of the global north. So we see Europe, Australia, the USA represented overwhelmingly here. Some of the kinds of cases have already been touched on by Jane, including the Italian cases. There's even more than the one that she referenced. There's one or two more looking at the predicament of victims of trafficking. And this case that I'm thinking of that's currently in the database relates to a person from an agricultural community in Pakistan who lost land in flooding, and through this kind of cycle of increasing impoverishment ended up becoming a victim of trafficking. And the court in Firenze in Italy decided that this person had satisfied all of the requirements of the Article 1 of the Refugee Convention and was a refugee with a well-founded fear of being persecuted as a member of a particular social group, being a former victim of trafficking and particularly at risk if returned to Pakistan. And that's a bit of an answer to one of those questions that came up in the chat as well about what about people not knowing about their possibilities of seeking international protection in another country, or let alone getting there. One of the ways people get to the global north is as victims of trafficking. So that's a partial answer there as well. We also see cases of politicized provision of disaster relief, both in terms of differential distribution. So governments might decide that only their supporters will get food aid, but we also hear, again, like Jane mentioned, situations of people having a presumed opposition political opinion by delivering food aid, and we've seen cases like that in a few countries. So when, as members of civil society, they take on the role of humanitarian relief, they can be victimized as a consequence and establish eligibility for international protection if they leave. We also see broader situations of food or water insecurity. We've seen this in a lot of cases in Somalia, and Jane mentioned some of those Austrian cases where the court will consider the possibility of people moving to another part of the country. This is the internal relocation alternative or internal flight alternative, and it can, in those kind of circumstances, establish that a person can't go to another part of the country. We've got quite a lot of cases like that on internal movement being precluded as a consequence of limited food or water availability in much of the accessible part of the country. We also have cases where there's a breakdown of public order. This isn't a case where there are specific provisions in regional international protection treaties in Africa and the Americas on breakdowns of public order. I'm thinking in particular here, though, of a Swedish case where in the aftermath of the 2010 earthquakes in Haiti, a person, a young woman, got recognized as being eligible for subsidiary protection under human rights law because of the risk of sexual violence that she faced in the broken down public order conditions in Haiti in the aftermath of that earthquake. So these are just a couple of the scenarios that are currently captured in the database, and we're going to go there shortly, but just wanted to prime you for that. But there's also quite a lot of internal displacement decision-making that's happening in different parts of the world. And here we're starting to see a little bit more diversity in the jurisdictions where cases are being decided. We have cases from the UN special rapporteurs. These are experts who have a role within the UN Human Rights Council, but act independently. And there's a number of communications that they've sent to different countries, primarily relating to situations of sort of forced eviction in the context of conservation or mitigation or adaptation initiatives. So there's a case, I'm looking at Pakistan here, where conscious of the need to adapt to urban disaster risk, a court ordered the eviction of inhabitants of an informal settlement on the outskirts of Karachi to be evicted in order to enhance the capacity to protect that city from flood risk. And the numerous special rapporteurs in that case expressed concerns to Pakistan, whilst expressly acknowledging the challenge that that country faces, having experienced massive flooding multiple times in recent years. But the concerns there related to protection of human rights, to adequate shelter in particular, and there's international standards relating to the prevention of forced eviction under the International Covenant on Economic, Social, and Cultural Rights that are particularly relevant there. We can dive deep into a lot of these cases, but time won't permit that. So I'll just highlight a couple more. We see situations where using domestic legal provisions, individuals and groups will bring cases for failures to, in these two cases I'm thinking of, evacuate people in vulnerable situations. We've got at least one currently on the database relating to the failure of a private ambulance company to evacuate people on a special needs list in the context of Hurricane Katrina in the USA, and those people died. And this raises lots of questions about the nature of the obligations of the state, how far they can outsource those obligations to third parties, and all kinds of other interesting questions. There's another really interesting case where persons with disabilities in Oakland in California brought a class action against the local government for failing to integrate their particular considerations or needs or realities into the emergency preparedness planning, including evacuation plans. I'm seeing sometimes chat pops up. I hope that's not Nandini trying to tell me I'm talking too long.
It's perfectly fine, Matthew.
Great. As I say, we can talk for a long time about these cases, and I'm kind of passionate about them because I think this is a new area that really warrants a lot of consideration, but I don't think time permits us to go into the detail because I also want to show you the database itself. So there's lots of other cases on the database. I'm not going to talk about them now. Instead, I'm going to see if I can seamlessly shift to the database itself, because that's what you're here for, or at least that's what I'm here for. Here it is. This is the Climate Mobility Case Database. You can see the partners here. We've got Earth Refuge, Global Strategic Litigation Council, the Raoul Wallenberg Institute, where I'm sitting, Zollberg Institute, and also importantly, we had a lot of support from DLA Piper and Eversheds Sutherland, which are global law firms. And in the beginning, their role was to actually mobilize their pro bono lawyers to identify and summarize a lot of these cases. As the cases started coming in, we realized that we needed a faster and systematic way of summarizing these cases. So we've moved to an AI option, and we have a bespoke AI summary tool that's been developed by our tech team. And some of the cases that you can see on the database have an AI-based summary. And the vision is that those AI-based summaries, which are flagged as AI summaries, will then be vetted by one of us in the team to make sure they're not saying something that's inaccurate. But this has also been something that's been in the works for at least a year. So we've tested and retested, and you can be the judge on whether you think they're good enough. But there's a need, we felt, to get the cases out as quickly as we could without making the perfect the enemy of the good. So here it is. This is the database. I'm waiting to get to the substance, but there's stuff at the top here that I want to bring your attention to. First of all, there's a feedback button. And that feedback button enables you to say this case is inaccurately summarized, or here's another case, which is super interesting for us because especially with this global ambition to capture a lot of cases, you play an important role. So if there are cases that you know about that you don't see on the database, let us know. It could be they're part of the 196 in the backlog, but it could also be that they haven't come to our attention. And I think that's highly likely. I do not believe that we have captured all of the cases yet. We've got an FAQ button and we've got a methodology button. You can dive into that at your leisure. In terms of methodology, yeah, I'm not going to go into it. Nandini, I haven't actually paid attention to time. How much have I got left?
I mean, there's only one question as of now, so maybe 5 to 8 minutes.
Yeah. Okay, good. So I won't talk about the methodology. I'll talk about the database and show it to you. So you already know why we developed the database. And now I'm gonna show it to you. So we open the database with a little bit of visualization. This is reflecting the current contents of the database, the 75 cases that are on there. You can break it down by type of mobility. So I'm going to give you the cross-border ones, which have more. And it shows you there in the cross-border visualization the constellation of cases. So most of them are starting around 2007 and onwards. It's not a huge volume as yet, but we expect, as we gather cases from other places, these numbers will grow, and we can also expect, as Jane anticipated in her presentation, that these kind of numbers will increase as well over time as the climate emergency exacerbates. So we can see similar dots in the internal displacement context as well. And you can see there, some of them are decided in favor of the state and others are decided in favor of the applicant. I don't think over time we'll see everyone getting some kind of satisfactory legal outcome, but we may see changes as the jurisprudence develops. And there certainly is an ambition underlying the database that compiling these cases in one place will facilitate the effective and progressive application and development of the law. So in the interest of human flourishing and international protection. And that means that the database is certainly useful to the original intended audience, which is the members of the Global Strategic Litigation Council. But it's also relevant for judges. It's also relevant for decision makers at local level. Think about those authorities developing the disaster preparedness plans. If they're aware that, Oakland had a class action that resulted in the need to rework the whole disaster preparedness plan to take into account the situation of persons with disabilities, then maybe neighboring municipalities will learn from that. And if they don't, maybe lawyers will learn that they can invoke the precedent in that case and encourage them to learn from it. Now, I'm slowly scrolling down into the actual dashboard of the database. You can see on the left, we've got a bunch of filters that can be helpful if you're looking for something in particular. If you're not looking for something in particular, you can just scroll down here and you'll look at all 75 cases. But let's say we're interested in cross-border displacement. Now we've filtered out, so we've got 48 cases. And let's say we're interested in France. Then we'll see an interesting, and I'll refrain from talking about it too much, but you can see quite a number of cases from France, and these happen to be concentrated around a particular domestic provision concerning the possibility of a person with serious health problems remaining in the country, even when they don't satisfy the requirements for recognition of refugee status or protection under human rights law. So we have those kind of cases captured as well. And some people might remember headlines being made about a person from Bangladesh who cited the serious air pollution in the country as a factor that supported his claim to stay in France because of his distinctive breathing problems associated with asthma or something like that. So the court there initially decided that this domestic provision would apply, and he was able to stay in France. And then the higher court, I think this is the one, the Administrative Court of Appeal in Bordeaux, changed or overturned that lower instance, and so he wasn't eligible. And there's a bunch of other cases like that from Mongolia, from Mauritania, from the Congo, that also show that maybe this isn't the avenue to pursue. So we're not also just highlighting successful cases, but cases that indicate that maybe this is a road that doesn't necessarily lead to international protection. You can also see, well, let's go into some of the detail behind these cases as well. And I can do that with internal. Let's turn off France. And we've got 27 internal displacement cases. I'm going to pick up the Kenyan case, and then I'll start to round off. So I was thinking in particular of a case called Lekulai and others. I wanted to show that because it's one of the AI generated summaries. and also because it's an interesting case that relates a bit to questions about durable solutions for people who are experiencing repeat instances of displacement. And in this case, people living around Lake Baringo were experiencing repeated displacements and took the authorities to court. And the court said this isn't enough to establish a challenge to the state. You'll have to figure out other ways to deal with the problem. But it's an interesting description of the kinds of situations that people are experiencing and how they're using law to attempt to secure some kind of remedy for displacement-related challenges in the context of disasters and climate change. So now you're actually seeing the substance of the database. You can see here the data, the decision, the judgment itself was in favor of the state where it was decided. Here's that disclaimer. You can link to the court judgment itself. I'm not going to do that because it'll mess up my sharing. We've got the country where it takes place, what the hazard is. And these are kind of variables that you can filter on that dashboard page that I showed you. I feel like time is not on my side, so I'm just going to tell you to look at some of these, and you can see what each of these pages for each of these cases shows is a description, details of the parties, the decision, some lessons learned, and maybe you even get details of the decision summary, some of the arguments that were advanced. So you get a pretty comprehensive overview of the case. Of course, you'll need to read the judgment yourself if you're going to be relying on it in any kind of formal context. Well, I think I'll wrap up and encourage you all to check it out and let us know if there are improvements that we can make.
Thank you so much, Matt. I